¿Cuál es el más fondo aquí en la sala?
¿Quieres que lo pongas en
Tengo el iPad.
Damos un rato si quieres.
Yo puse una página ahorita.
Muy bien, la sexta conferencia es Situación de la Justicia Militar en el Mundo. El moderador de esa mesa es el señor Dimitrios Zafiropoulos. Él es teniente general, nació en Atenas. Se graduó en la Escuela de Leyes de la Universidad de Tesaloniki, Grecia. Además, posee un máster en Derecho Internacional Público de la Universidad de Londres. Actualmente es el fiscal supremo de la Corte de Apelación Militar de Atenas y primer vicepresidente de la Sociedad Internacional de Derecho Militar y Derecho de la Guerra. Señora, adelante.
Gracias. Welcome to the second session of today's program. As you probably know, the question has played is still plays and apparently it will continue to play in the future quite a significant role in the judicial space across the globe. Here you may see the famous speaking of George Bernard Shaw, as was also mentioned yesterday. Military justice is justice what military music is to music. It means that military justice is one justice, an important part of it. Militaries throughout the world, of course with exceptions, operate their own service tribunals to prosecute military crimes, which are not part of civilian criminal codes. And certain states have traditionally extended this jurisdiction to cover all crimes committed by their personnel, no matter if they are military crimes or not. The reason behind this seems to be that those states want to secure a rapid conclusion of the criminal proceedings and to ensure that more severe penalties are imposed to the perpetrators. This is quite normal and absolutely acceptable to this point. The difficulty lies in states where the reason for this extension is different. It is related to the long-standing effort from the part of the administration to prosecute and to try offences committed by its own military personnel, ultimately to try its own offences, with the purpose to cover their criminal character and to have punishments escape. This is quite an abnormal situation and cannot be seen in democratic societies where the principle of equality before the law cannot be eroded, the civilian control over the military cannot be threatened, and the culture of impunity cannot be fostered. Those simple thoughts bring us to the point to underline the importance of particular parameters where military courts should operate. The question whether the whole structure of military jurisdiction in a certain country is subordinate to either the Minister of Defense or the Minister of Justice is not an issue. Nor if both civilian and military criminal courts and courts of criminal jurisdiction, very modern in character and very democratic, are enforced in a certain country. What really counts is that states must situate the development of military justice within the framework of the general principles for the proper administration of justice contained in the Universal Declaration of Human Rights and in the National Covenant on Civil and Political Rights, as well as in the regional conventions or other relevant instruments, which are unambiguous regarding justice. In other words, military justice must be an integral part of the general judicial system. At the same time, what follows is a minimum system of universally applicable rules, leaving scope for stricter standards to be defined under municipal law. As a short introduction, I would like just to mention that the history behind the issues related to the UN Commission on Human Rights, which in its 63rd session referred to the continued study on the issue of administration of justice to military tribunals in two mutually complementary resolutions adopted on the 19th of April 2005. One of those took note of the report submitted by Professor Emmanuel Dehaut, apparently you may know that, to the Subcommission on the Promotion and Protection of Human Rights, which included draft principles on the issue, and also noted that this report containing an updated version of those principles would be subject to the Commission at its next session. And the Commission thus established both the conceptual framework and the schedule for the study and marked the end of the undertaking in which the Subcommission has been engaged for several years, beginning with the questionnaire drawn up by Louis Guinet for his report to the Subcommission at its 53rd session. In 2006, Dehaut, who was the special rapporteur of the Subcommission on the Promotion and Protection of Human Rights, elaborated a set of draft principles governing the administration of justice through military tribunals, whose aim was to establish a minimum system of universally applicable rules to regulate military justice. They were developed in consultation with human rights experts, jurists, military personnel from throughout the world, and include particular provisions relating to the establishment and functioning of military tribunals. As already indicated, those principles are based on the idea that military justice should be an integral part of the general judicial system. The principles have already been positively cited in the jurisprudence of the European Court of Human Rights. They are 20 in number, and they are being repeated on the stage. Now, the translators are requested to translate those principles in Spanish because I don't have the those principles in Spanish. In accordance with our program, we'll be having 1 hour and 40 minutes of the session. Apparently, the time allocated to us is not, it's quite short to allow us to present adequately a global perspective on the issue. What we have done is we have identified the excellent colleagues and friends sitting next to me from Balance Corps, who were kind enough to accept our invitation to be with us this morning and to make a short intervention expose based on their experience and knowledge, not only arising from their own country, but also from center and regions of the planet. Unfortunately, as it has been already indicated, we had the 4th speaker just report from the United States at the very last moment, but unfortunately, he had to cancel his presence here because of the floods that we had to suffer over the last days in Houston by years. Now, this intervention will be around 20 to 25 minutes long, in an effort to leave some time at the very end before we conclude to address your concerns and to answer your questions. Ladies and gentlemen, the first speaker, we can start from the north, Norway, is Arne Vigdal, who's sitting next to me. Arne Vigdal was born on February 22nd, 1949 in Oslo. He received his university law degree in 1974. He was just Advocate General, actually the head of the Military Prosecution Authority in the Norwegian Armed Forces from 1989 through 2014. And he had to retire in July 2014. He was the president of the International Society on Military Law and the Law of War from the year 2006 through the year 2012. And as you may see, the program, and as you may know, is right now our honorary president. I really give you the program.
Thank you. Journalists, hosts, ladies and gentlemen, friends and colleagues. It's an honor to be invited to address this distinguished audience today. I thank our host for having invited me, giving me also the opportunity to listen to other presenters. My manuscript is available with the organizers and the General Secretariat of the International Society for Military Law and the Law of War, unless you want to contact me directly in order to obtain it. As you may already know, my homeland is Norway, which has a more or less fully civilianized system for administration of military justice. My country has its own challenges, while other countries have theirs. The ambition of this presentation is to give an outlook on developments internationally in military justice and provide a balanced view of strengths and weaknesses of various systems from a human rights perspective in the broad sense. Although my presentation is focusing on developments in the field of military courts, it should not be forgotten that military justice is also about investigation and prosecution. Independence, impartiality, and competence of investigators has in recent years been considered in cases before the European Court for Human Rights. I shall not go further into these aspects today, but only remind us that one needs to consider the whole procedural chain, from investigation via prosecution to adjudication, before drawing conclusions about the qualities of a particular system of military justice. One should also keep in mind that many, possibly most countries have systems for dealing with disciplinary offenses of a minor nature by summary punishments. These systems may be more or less seamlessly connected to the respective penal military justice systems, or be separated from, for instance, by having legal provisions defining which offenses are to be handled by penal procedure and which by summary punishment. Summary punishment is almost without exception a matter for the commanding officer and may pose their specific concerns with regards to the human rights of the accused. This said, the military courts have the final word in the more serious cases and deserve particular attention. In the following, I shall use the term military court in an extended sense, including any court that decides military penal cases or closely related offenses in the military. In a historical perspective, military justice has its roots in the authority of the commanding officer and his need to maintain discipline among his troops. When Alexander the Great took his army to Persia or Roman legions or in North Africa, it would have been utterly impractical to bring military cases back to a court in Macedonia or in Rome. The relationship between the warlord and the state was also different from what it is in modern democracies today. Without a successful warlord, there would not be any state. The head of state was, up to Napoleonic times, more often than not the supreme warlord. Although society developed and the army became, at least in principle, servant of the state, represented by civilian authorities, one may say that up to and including the Second World War, the practical situation was not very different, at least not in wartime. How could, for instance, the United States of America have sent offenders home for trial or brought the civilian district court to Normandy in 1944? In peacetime, however, the situation is different. Usually, a district court can be found not too far from most garrisons. In Norway, this made it possible to abolish military courts in peacetime in 1921. Even in overseas deployments, it's nowadays not impractical to put the alleged offender on a flight home for trial. Somewhat more difficult, but not impossible, to fly a court in the mission area far from the homeland. In other words, the situation is different today. Although the armed forces are in general perceived differently nowadays than, say, in Napoleonic times, perceptions differ between countries and within countries. Are the armed forces simply a branch of the executive, like the police, customs, tax, health, or education services? Do they require a particular sort of expertise, which entails that civilians have problems with understanding military affairs? Are they actual or potential terrorists expected to and ready to make sacrifices for a country that are not demanded by other citizens? Are they guardians of the state, from which time to time may suffer under the wings of irresponsible or corrupt politicians, so that the armed forces finds it necessary to take corrective action? Be that as it may, in the long run, the armed forces need the confidence of the population at large. One important factor in this is that they do not abuse their power against other segments of society. Another is that they are seen to treat their own members fairly, giving soldiers that are accused of crimes a fair trial. Neither should they bring their country into disrepute by shielding war criminals or perpetrators of other grave international crimes. The evident solution seems to be that possible crimes are investigated, prosecuted, and judged by independent courts. But solutions are rarely perfect, although they may be based on good principles. When a principle is pushed into the extreme, it's likely to clash with some other equally valid principles, which means that you have to look for a reasonable compromise. I shall come back to this later. Our conference is not the first, and certainly not be the last, that concerns itself with military justice. Over the last couple of decades or so, a wave of interest in and reforms of military justice systems has swept over the planet, which can be seen reflected in a number of conferences and other meetings around the globe. A summary list of events that I have been aware of where military justice has been the only or a major theme is given below. I have already learned at this conference that this list is not complete. It lacks several meetings which have been here in this part of the world, Latin America. I shall not go through that list, but focus on the 2001 Rhodes Conference. In 2001, the International Society for Military Law and Law War set out to do a comparative analysis of military justice systems. A similar analysis had been made at the 1979 Congress in Ankara, and the Society found it appropriate to take a new look at the issue. Both in 1979 and in 2001, a questionnaire was distributed in order to gather information for the analysis. For the purpose of the present conference, the most interesting question in the 2001 questionnaire was the following. Please indicate whether there has been any recent discussion, evaluation, or reform of your military legal system with reference to human rights, such as those laid down in the European Human Rights Convention or other comparable instruments applicable to your country. Details should be reflected in the answers to the questions below. The answers show that a good number of responding countries have gone through significant reforms or were considering possible future reforms. Developments taking place in the following years confirm that the reforms were part of an ongoing process, more or less over the whole world. The number of changes in international military justice systems can present a confusing picture. To identify trends, one has to simplify matters, not only in detail. My first simplification is to divide military justice systems into two groups. The 2001 survey showed that the systems in 35 respondent states could be divided into so-called Anglo-American systems, based on courts martial convene for the individual case, and European continental systems, based on standing courts. Anglo-American systems were first and foremost found in Great Britain and in their former colonies, while some states with European continental systems might have had systems resembling the Anglo-Americans in a more distant past. It should also be noted that several states have dispensed with military force altogether, having military penal cases heard before civilian courts. In some states, this might be a civilian court with some specialization or military element. In other states, the court could be a truly civilian, non-specialized court. The systems could also be different in peacetime and in wartime. This leads me to distribute the various military justice systems along an axis, with the traditional fully military courts martial system at one end and the fully civilianized system at the other. And you may yourself consider in which box you find your own country system. There are, of course, lots of individual variations within each box, so this is still a simplification. Virtually all changes in military justice systems that are known to me, and that is more than a dozen, have been from the left to the right in this table. Let me give you some examples. In Australia, standing military courts were introduced in 2005. However, the reform was reversed in 2009. And we shall hear later more details about this. In Belgium, since January 2004, military courts are abolished in times of peace. The military courts were accused of corporate justice. In Czechia, the military courts were abolished in 1993. That was a consequence of general political reorientation in that country. In Hungary, around 2012, military prosecution was integrated into the civilian. In Ireland, there has been a review to adapt to the European Convention on Human Rights, based on British reforms. The military cases are now heard by standing courts with permanent judges. Since we have a presenter from New Zealand here, I shall not say anything more about that. We shall hear later. A possible exception from the trend is Australia, which went from a traditional system of court-martial, convened for the individual case, to a standing deployable court of civilian judges who have military experience or knowledge of military affairs that soon reversed back for constitutional reasons. It may also be mentioned that in Germany, criminal cases from missions abroad have, in 2013, been centralized to one specific civilian court, making it possible to build up a certain expertise in military affairs at the court. Regarding Latin America, the participants in the 2015 Congress of the Society were informed about developments concerning Argentina, Bolivia, Chile, Ecuador, Peru, and Uruguay. As far as I have understood, these developments confirm the general impression of a trend from left to the right in the table. The developments seem to have been driven mainly by human rights influence. Human rights influence has been seen to be particularly strong in states party to the European Convention on Human Rights and states affiliated to such states, typically Australia, Canada, and New Zealand. The reason for this seems to be access for aggrieved individuals to obtain binding decisions by the European Court of Human Rights. Such decisions, the Convention is not only applied, but also interpreted in a way that it takes a measure of progressive development. Highly relevant is Article 5, Paragraph 1a, which lays down everyone has the right to liberty and security of person. No one shall be deprived of his liberty, save in the following cases and in accordance with that procedure prescribed by law, etc. Equally relevant is Article 6, Paragraph 1, which lays down in the determination of civil rights and obligations or of any criminal charge against it, everyone is entitled to a fair and public hearing within a reasonable time by an independent and impartial tribunal established by law. These articles impose restrictions on the extent to which punishments can be awarded by summary procedures without due process. They also demand that military courts have to be independent, which means that you can have a court composed of officers convened by a commander who may have an interest in the outcome. And although the courts may in fact act in a truly impartial manner, justice must not only be done, it must also be seen to be done. Another source of influence is the UN Human Rights Committee. This body has been skeptical with regard to military jurisdiction over civilians. It seems to have been out of concern that military courts may not be impartial in cases that could be seen to have national security implications. In a report of the Special Rapporteur on the independence of judges and lawyers prepared for the United Nations General Assembly in 2013, it said that military jurisdiction should be restricted to offenses of military nature committed by military personnel. Actually, repeating the previous report. From time to time, there are eruptions of general distrust towards military courts on the part of the general public as represented by mass media and politicians. Criticism may be sparked by more or less unfortunate events and may or may not be well deserved. For example, United Kingdom troops were involved in some nasty incidents in Iraq in 2003 and 2008. In cases where it had been decided there will be no prosecution in the army or military, the army, military, police, or the government have been accused of politically motivated cover. Other cases where there had been prosecution of their voice asking, why are you prosecuting anybody when they are trying to do a difficult and dangerous job in an operation that we should never have embarked on in the first place? And there were also accusations of having indicted the war-on person to go to the soldier after the soldier instead of the general, or the other way around. Similar criticism has been called in other countries, in countries where the military has a traditionally strong position, such as some Latin American states. Jurisdiction on military courts of civilians has been an issue in conjunction with the concerns of the UNHRC. In a wider group of countries, an issue has been to limit the jurisdiction of military courts to strictly military offenses, thus leaving, for instance, cases of theft to civilian courts. What may be relevant and pertinent in a national peacetime perspective may, however, prove dysfunctional when troops are deployed abroad. When soldiers commit crimes against local civilians whom they are supposed to protect, it does not make a good impression to put their use on an airplane for prosecution at home. The local affected civilians need to see that justice is done, which is best demonstrated by having deployed the courts. This does not go well together with a civilian justice system. In this connection, it can be mentioned that statutes typically allow for exercise of jurisdiction by military courts of the sending state, while civilian courts exercising jurisdiction on foreign territory is an anomaly. Another factor is the increasing use of civilian contractors in conjunction with military forces. If military commanders have no summary punishment jurisdiction over such persons, and military courts that could be deployed have no penal jurisdiction over them, the end result could in practice be impunity. The potential of scandals or at least complicated and inefficient prosecutions is evident. In criminal cases, the court needs to know both the law and the factual aspects. Expert witnesses are often called upon to explain details of wounds or weapons that may shed light upon what the accused may or may not have done or intended to do. In economic cases, accountants may be called in to explain what the accounts show with regard to possible tax fraud or whatever the case is about. In some sectors, many countries have concluded that specialized courts are needed to deal effectively with particular cases. One may ask whether it could also be relevant for military cases. In my country, where the system is truly civilianized in peacetime, the specialized prosecutors have told me that they often have to explain important aspects of the case to the court, aspects that would have been known to the court if its members had some basic military experience. If the defense counsel too has to rely on the explanations of the prosecutor, one may ask whether the trial is really fair and balanced. Independence of courts is a key issue in the European Convention for Human Rights and in our discussion today. Are the members of the court independent of someone who might have an interest in the outcome? The importance of independence was demonstrated in a recent case in Norway. Although about summary punishment and not penal sanctions, strictly speaking, it shows how the principle works. A lieutenant had been awarded a summary punishment for having ordered a female soldier to wash herself in the nude in a river against her will during a field exercise. Male soldiers were present but had their backs turned to the girls in the river. The case had a high media profile when it became known shortly after the event in the fall of 2011. The media profile became even higher when the officer presented new evidence, which led the complaints board to reconsider the previous decision and push the summary punishment 3 years later. Armed forces wanted to have the punishment upheld. The ministry was clearly on the safe side, and the mass media was strongly supporting the young woman against the officer. But the complaints board, led by a professional judge, came to the opposite conclusion. After having reviewed all the evidence about exactly what had been said or done in which sequence and taking into consideration that official guidance was lacking about how to adapt general practice of washing oneself in the field to the fact that both genders nowadays are represented in the armed forces of Norway. After having followed the debate, and I actually was called upon to show up in national broadcasting, I must say that I understand Pilate better, who was told that if he did not condemn Jesus to being crucified, he would not be the emperor's friend anymore. How can the independence of churches be assured? Courts-martial that are convened for the individual case have a certain semblance to the jury system, which is well known, particularly in countries with an Anglo-American legal tradition. If the members are appointed, one should ask by whom. If they are drawn by lot from a list, one must still ask under whose command will they be after they have performed their duty at the court. Might their careers suffer if they deliver a verdict which is not viewed favorably with their superiors? Some degree of anonymity might mitigate the problem, like when a Norwegian jury answers guilty by more than 6 votes, thus concealing which member gave which vote. For standing military courts, an important question is who decides the career of the judges. Will they serve for a limited number of years, after which a military commander will decide their next post, or will they have security of job and pension, independent of whether their decisions are viewed with favor by those in power or not? Although the judge may be independent, he may feel the pressure. The Finnish military judge, Paavo Alkio, writes in his memoirs from the Second World War about the number of instances when the division commander disapproved of his judgments. The caseload ranged from theft and absence without leave to mutiny and espionage. The division commander wanted more capital punishments in the more severe cases in order to set an example, while the judge focused on the guilt of the individual accused. Although he had the security of his peacetime position of a tenured judge to fall back upon, the pressure could be felt by Judge Alkio in matters of whether his application for leave were granted or how medals of honorable service were awarded among military judges. What is an offense? If a soldier murders his wife, is this a case that ought to be handled by a military justice system? One may say that a murder is a murder and can be handled equally well, if not better, by civilian investigators, prosecutors, and judges than by the military equivalents. What if a fellow soldier steals from his fellow soldiers? Is this a case of military nature? It may not have been included as a provision in the military penal law. It will certainly affect the cohesion and effectiveness of the unit involved. The commanding officer would perceive a need for having the case investigated and solved quickly, maybe with a higher priority than the civilian police, if within reach, would give the similar offense involving 2 civilians. To this comes that the dividing line between military and civilian offenses may be fluid. In Norway, as long as security regulations existed only within the military branch of security, short of espionage, was a branch of service duties, in other words, a military offense. When in 1999, general legislation on security was enacted in Norway, branch of security became implicitly a civilian offense. After adoption of the 1998 Rome Statute for the International Criminal Court, a number of countries that enacted implementing legislation. War crimes, crimes against humanity and genocide, also known as core international crimes, have been defined in national law more or less based on the Rome Statute. Are such crimes of a military nature and should they be dealt with by military courts? Some would explicitly exclude serious human rights violations from the jurisdiction of military courts. The main concern has, however, been about cases where members of the armed forces are accused of serious violations such as extrajudicial executions, enforced disappearances, and torture. If such crimes take place within a country that is torn by civil unrest, there could be reasons to fear that the military might be tempted to shield perpetrators, and that the cases should for this reason be handled by the civilian justice system. In other countries, the focus of attention would be on possible war crimes committed by members of the armed forces. Also in these cases, dividing line may be fluid. For example, if a soldier intentionally shoots a civilian, now at the battlefield, it's a war crime. If he does so in the erroneous belief that the civilian was directly participating in hostilities, it may be a breach of the 1977 Additional Protocol 1 to the 1949 Geneva Conventions, if he did not take all peaceful precautions to verify that he was attacking a local target. This is not necessarily a war crime, at least not under the 1998 Rome Statute. It may also happen that he did not aim at the civilian at all, but used his weapon in breach of the applicable rules of engagement. This will turn the act into a military offense. Now, the issue of which law applies may not be apparent before the case has been investigated. It may be clear that the civilian has been shot and that the soldier must most likely bear some responsibility for it, but it can be uncertain up to the point of sentencing under which law. This said, it may be noted that cases about crimes against humanity or genocide do not necessarily have a significant future component. The perpetrators may be civilian, as they typically were in Rwanda, or the acts themselves were not part of a military operation, such as when the inmates of a concentration camp are mistreated. The link to the military can be tenuous or totally absent, and the arguments in favor of military involvement in investigation, prosecution, or adjudication is weak. Such cases are not the focus of this presentation, but those that have a clear connection to military activity. My recommendation would therefore be that in cases, in particular those that arise from military operations, the jurisdiction of core international crimes and military offenses should not be divided more than strictly necessary. This is particularly relevant in an investigation phase when it may be unclear whether one is facing one or the other. There are clear trends in the development of military justice to be seen on the international scene with regard to the rights of the accused with reference to human rights standards. The important elements are more independence to judges, standing courts, increased right to elect trial instead of summary proceedings, increased right to legal representation. There are furthermore trends with regard to shifting from military to civilian jurisdiction, particularly in peacetime, by reducing the competence of military courts, abolishing military courts, abolishing military prosecution. The important question with which many countries struggle with, is whether military commanders should give up their control of the military justice in order to have a system that is perceived as fair by the general public. Equally important is, however, whether the process as indicated by current trends should be allowed to run to the other extreme, separating investigations, prosecutors, and courts totally from the military structure, or whether one should seek some compromise solution.
We will be moving south now, South Hemisphere actually, making a stop in New Zealand and meeting our second intervener, who is Christopher Phillips. Chris is a barrister and a national legal consultant practicing from the Wellington Chambers of Barristers in New Zealand. He acts for a broad range of clients in his country and oversees on a range of civil and criminal matters, both at the domestic and international level. Between the years 2002 and 2009, he was the architect of substantial reforms to New Zealand's military justice system. And his last military appointment in the rank of commander was as chief legal advisor at Headquarters Joint Forces New Zealand. He's active with the ICC, and he's a member of the board of directors of the International Society for Military and Law of War, where he's supporting the activities, the overall activities in a very active way. He will be passing over to us the current trends of military justice in Oceania and not only. Please, you have the floor.
Kia ora Jero, ina mana, ina reo, ina manuhiri tēnā koutou, tēnā koutou, tēnā koutou katoa. Almirante, generales, señoras y señores, buenos días y muchas gracias por haberme invitado a su hermoso país. Lo siento que no hablo mucho español, so I will speak in English. Article 14 of the International Covenant on Civil and Political Rights provides, amongst other things, that in the determination of any criminal charge against him, everyone shall be entitled to a fair and public hearing by a competent, independent, and impartial tribunal established by law. This is a principle of such universal acceptance that it seems incontrovertible that it is now part of the corpus of customary international law. The more difficult question is how this principle is to be applied in military justice systems. I'll just pause for a moment while my slides load up. I will proceed without the slides. I'm afraid there's some pictures which you'll miss, but I'll do my best to make that to you. So, this morning you've already heard about Principle 13, the co-principles referred to by General Zafiropoulos. I'm going to focus a bit on Principle number 13, and it says this: the organisation and operation of military courts should fully ensure the right of everyone to a competent, independent, and impartial tribunal at every stage of legal proceedings, from initial investigation to trial. The person selected to perform the functions of judges in military courts must display integrity and competence and show proof of the necessary legal training and qualifications. Military judges should have a status guaranteeing their independence and impartiality. In particular, vis-a-vis the military hierarchy. In no circumstances should military courts be allowed to resort to procedures involving anonymous or faceless judges and prosecutors. And the manner in which this minimum standard is reflected in the domestic law of states' parties varies widely. In the report by Special Rapporteur Gabriela Knaull, which was referred to earlier by General Darr, it was stated that Anglo-American systems of military justice are characterised by ad hoc courts-martial convened for particular cases. And this observation was repeated by the UN High Commissioner of Human Rights in January 2015. Unfortunately, that remark displays the lack of currency with development of military justice in common law countries, and is now an oversimplification. In both New Zealand and the United Kingdom, those nations' parliaments have established staggered courts to establish and exercise military criminal jurisdiction, albeit they are still called the court-martial. The nomenclature has been retained for reasons of history and tradition. But we should not overlook the fact that the court-martial of New Zealand and the court-martial in the United Kingdom are fundamentally different concepts to their ad hoc antecedents from the perspective of compliance with international human rights law. The ad hoc system does remain in place in Australia, Canada, and the United States, but the Canadian system has been subject to a number of significant reforms, which I leave for Colonel Holman to describe. It's not useful, in my view, to make generalizations. Each system of military justice around the world is unique, and it's important to analyse each system in its historical, cultural, military, political, and constitutional context to derive useful lessons for our own military laws. It's something that I had to deal with. Oh, sorry, a couple of slides. I'm not going to ask you to read that this time to skip past it. Actually, I'll leave it up. I had this experience in Australia after I pushed through reforms in New Zealand. I was about to go to Australia to talk to them about what we had done with a view to lessons being learned. But what became very clear quite early on is that the things that we had done in New Zealand could not be done in Australia because of their constitutional limitations. So good ideas in one country are not necessarily good ideas in another. I'm now going to talk a bit about my own patch of the ocean, Oceania. I say patch of the ocean, I was always going to say continent, but it's mostly water. There's a bit of an oxymoron to call it a continent. I'm going to make some limited comments, and I'm happy to take questions on any other aspects of the systems I've described. So first of all, my own country, New Zealand. There's a picture. This is a picture of various force elements of the New Zealand Defence Force. And here's those rather attractive young men in the corner there are doing that, which I will not be doing during this presentation. Sorry to disappoint you. In New Zealand, the change to the status of the court-martial took place on 1st of July 2009 with the coming into force of the Court-Martial Act 2007. That act established the Court-Martial of New Zealand as a permanent court of record. New Zealand, unlike most countries except the United Kingdom and Israel, has an unwritten constitution, so it's open to the Parliament to create a new court within the judicial branch without the sorts of constitutional problems which Australia has faced. The judge advocates who sat with New Zealand's courts martial under the old ad hoc courts martial system had been civilian judges and senior civilian lawyers since the military justice system was unified in 1983. So it was not a huge step in a practical sense to make them fully fledged judges of the new court. There are many practical advantages, in fact. They are now full members of the New Zealand judiciary, albeit on a part-time basis, and have the same eligibility requirements and guarantees of judicial independence as judges in the ordinary criminal courts. While they can attend to interlocutory matters alone, they only try cases with a panel of 3, or in serious cases, 5 military members. It is those members who act like a jury or assessors in a civil law context, who bring the essential knowledge of military context and values to the proceeding. An important point that I think is key here is those officers are commanders. They are not lawyers. And they have contemporary experience of the operations of the armed forces. So they bring that military context. It's the military context of today and not 15 years ago. So the consequence of that is that the focus of appointing judges of the court martial has shifted away from appointing only judges or lawyers with a military background, which is an increasingly rare commodity in the modern era, at least in my country, towards appointing high caliber, experienced trial judges who have personal qualities that fit them to act as a judicial officer in the military context. The last step is for the Ministry of Justice to take over financial responsibility for the registry of the court martial from the New Zealand Defence Force. The New Zealand Defence Force is very keen for that to happen. So far, they haven't persuaded the Ministry of Justice to do so. In line with principle number 20 of the Code Principles Principles, I'm currently assisting the New Zealand Defence Force with something akin to a periodic review of the New Zealand's military justice system to ensure that it's compatible with the ordinary criminal law as can be achieved without sacrificing any of the vital elements of the military justice system. There is no intention to move towards administering military law through civilian courts. And I do not see that as likely, given that it would undermine the vital elements of portability in a military justice system serving armed forces which are primarily expeditionary in nature. Our big cousin to the west, Australia. This is another, the Australian Defence Force also has a primarily expeditionary focus. And if you know, if you read newspapers, watch the news, they are in many theatres around the world at various times. The Australian government has tried on 2 occasions to move that country's military court structure towards a standing court, but has been unable to do so because of constitutional difficulties. Chapter 3 of the Australian Constitution governs the exercise of the judicial power of the Commonwealth of Australia. In particular, Section 72 prescribes that federal judges are appointed by the Governor-General and Council and hold office until retirement unless they are removed from office for misbehaviour or incapacity. This can only occur if approved by the Governor-General at the request of both houses of the Australian Parliament in the same session. So in 2005, a committee of the Australian Senate conducted an inquiry into the effectiveness of Australia's military justice system and recommended a system of ad hoc courts martial and defence force magistrates be replaced with a permanent court established under Chapter 3 of the Constitution. The government response agreed to the establishment of a permanent court, to be called the Australian Military Court, on the ground that it would promote the aim of military justice being administered by a court which was objectively independent, as required by Article 14 of the International Covenant. However, the government did not agree to the Australian Military Court being a Chapter 3 court. The intention was the court being established pursuant to the defence power in Section 51(6) of the Constitution, which provides that the Parliament shall, subject to this Constitution, have power to make laws for the peace, order and good government of the Commonwealth with respect to the naval and military defence of the Commonwealth and of the several states, and the control of the forces to execute and maintain the laws of the Commonwealth. The reason given by the government for not wanting to establish the court as a Chapter 3 court as follows. Importantly, the military court is not an exercise in ordinary criminal law. It is a military discipline system, the object of which is to maintain military discipline within the Australian Defence Force. It is essential to have knowledge and understanding of the military culture and context. This is much more than being able to understand specialist evidence in a civil trial. There is a need to understand the military operational and administrative environment and the unique needs for the maintenance of discipline of the military force, both in Australia and operations and exercises overseas. The judicial authority must be able to sit in theatre and operations. It must be deployable and have credibility with the acceptance of the Defence Force. The principal factor peculiar to the Defence Force is the military preparedness requirements and the physical demands of sitting in an operational environment. The Chapter 3 requirements are not consistent with those factors, and the government does not support the Chapter 3 features for a military court. So when Parliament amended the Defence Force Discipline Act 1982 in 2006 to establish the Australian Military Court, it was not established as a Chapter 3 court. In particular, its judges were required to be military officers. They were appointed to their judicial office by the Minister of Defence, and they were appointed for fixed 5-year terms with the possibility of renewal. Unfortunately, this legislation did not survive for long. In 2009, the constitutional legitimacy of the Australian Military Court was successfully challenged in Australia's Court of Final Appeal, the High Court of Australia, in a case called Lane and Morrison. Mr. Lane was a former naval rated who was scheduled to be tried by Colonel Morrison, a judge of the Australian Military Court. The High Court held that precisely because of the steps which had been taken by Parliament to divorce the Australian Military Court from the chain of command in order to promote its independence, the court constituted an exercise of the judicial power of the Commonwealth. As the court did not comply with the requirements of Chapter 3, that is judicial independence, that was unconstitutional, and the 2006 amending legislation was therefore invalid. It followed that the Australian government needed to return to the old command-based system of ad hoc courts martial and defence force magistrates while it considered how to legislate for a system of military justice that would comply with the Constitution while moving closer to the requirements of Article 14 of the International Covenant. This was done through the Military Justice Interim Measures Act No. 1, 2009, which came into force in September of that year. The interim appointments of judge advocates were originally supposed to expire after 2 years. In the meantime, the government introduced a Military Court of Australia bill on 2 occasions in 2010 and 2012. That would create a military court pursuant to and complying with Chapter 3 of the Constitution. However, subsequent political challenges faced by the government in progressing these measures through Commonwealth Parliament have meant that the interim appointments of Judge advocates have needed to be extended on 3 occasions. And the most recent amendment in 2015, the appointments of Judge advocates have now been extended up to September 2017, and it seems unlikely that Australia will move away from the ad hoc court-martial system in the foreseeable future. So, Fiji, only 3 other states of Oceania have armed forces: Fiji, Papua New Guinea, and Vanuatu. The Republic of Fiji military forces are based around 3 infantry battalions, 2 of which are usually deployed on peace support operations, a naval squadron, and other supporting units. The discipline of the RFMF is governed by the Republic of Fiji Military Forces Act. Under Section 23 of that Act, the military law which applies to the RFMF is the Army Act 1955 of the United Kingdom, including, quote, all acts amending, replacing, or read in conjunction with the same, and all rules, regulations, and articles of war made their own. The difficulty with this incorporation of British law from a Fijian perspective is that the United Kingdom has essentially completely replaced its military justice system in recent decades. There are serious reasons to doubt that Fiji is actually operating its military justice system in compliance with the Armed Forces Act 2006 of the United Kingdom, which is the successor to the Army Act 1955. For example, the Republic of Fiji Military Forces Amendment Act of 2015 indicates that the RFMF is still convening ad hoc courts martial, which are not permitted under the Armed Forces Act 2006 of the UK. This is an area of significant vulnerability for the RFMF and the government of Fiji. Papua New Guinea. The Papua New Guinea Defence Force, or PNGDF, is a similar size to the RFMF, with land forces, naval squadron, and air wing. Discipline of the PNGDF is governed by the Defence Act 1974. Schedule 1 to that Act confers significant powers of summary discipline on the commander of the PNGDF, and officers holding delegations from them were known as disciplinary officers. This can include the punishment of dismissal or detention up to 84 days. Under Section 45 of the Defence Act, jurisdiction over military offences is also conferred on the Defence Force judge, who must be a judge of the Supreme Court or the National Court. This jurisdiction can be delegated to Deputy Defence Force judges who are qualified for appointment as judges of the Supreme Court or the National Court. When these judges exercise jurisdiction, which they may do anywhere in the world, their court is styled Court of Military Justice. In addition, Section 46 of the Defence Act provides for magistrates of district courts to be appointed Defence Force magistrates and to establish jurisdiction over military offences in that capacity. The problem. Section 37, paragraph 3 of the Constitution of the Independent State of and is referred to as the Vanuatu Mobile Force. The discipline of the Vanuatu Mobile, the Police Act, under that Act, while senior officers have some limited powers of summary punishment, they are not able to impose a true penal consequence, which would trigger the application of constitutional rights. An offence of any significance by a member of the Vanuatu Mobile Force must be tried in the ordinary courts. So what's the takeaway from that? I just talked to you about a small handful of states in one region of the world. As you can see, they are quite different. And they have different ways of approaching the same task. And I'm not here to say that any one of those is right or wrong. They're simply different. Viva Femos. Thank you.
At the other side of the planet, in the Americas, in Canada, we'll be meeting Colonel Robin Coleman, who will be the third and last intervener for today. Colonel Coleman was born into an Air Force family. He joined the Canadian Armed Forces in the year 1986, and he has received his pilot wings in 1991. From the year 2002 through 2007, he served as a military prosecutor, first as trial counsel before court-martial, and later as appellate counsel, appearing in front of the court-martial appeal court in Canada. In the year 2010, he earned a master's degree in international law from the famous and very renowned McGill University in Canada, Faculty of Law. He promoted to the present rank he has, the rank of colonel, as already mentioned, in the year 2013. And he assumed the responsibilities of Deputy Advocate General for Military Justice. Once again, it is a privilege to give you the international.
Thank you, General. Excellencies, Generals, Admirals, colleagues, ladies and gentlemen, I'm very happy to be here, and I would like to thank the organizing committee, the Foro Militar Policial, and the Society for the invitation. It's humbling to find myself as the last speaker, not only of this panel, but in fact the last speaker of a series that stretches into yesterday, dealing with matters of military justice, and recognizing that I'm one of the things that stands between you and what I expect will be an excellent lunch. I will try to be brief. I'd like to start, and I'll say that my focus is going to be initially on some of the aspects of international law that we've been discussing, and I'll interject little bits and pieces of the Canadian perspective on those as I go through. But I'd like to start by building on something that Admiral Pacheco and General Martinez both touched upon yesterday, and that both of my fellow panelists have this morning as well. And that's that although military justice systems all have the same goal, discipline, efficiency, morale, and through them operational effectiveness and public legitimacy, to use one of the Army's principles of war. No military system, again, that's the point that's been made, exists in a vacuum. And it behooves us, it seems to me, it's important to us as scholars, as practitioners, as people who have a role in forming military justice policy for our own countries, to be fully informed of all of the relevant comparator systems. No system exists in a vacuum. There are historical, social, political, legal, constitutional factors that go into the system that exists. And without taking away from the long-term efforts, I think, of the Society, of the International Association for Military Justice, I think it would be wrong of me at this point to not express my respect and admiration for the efforts that Pacheco and General Martinez have both made in the American context to try and bring us all together to understand each other's social, political, legal, constitutional histories, and therefore each other's systems, so that we can understand where we might learn best lessons from each other, and where we might be able to teach lessons from our own experience to each other. It seems to me that one of the biases that many critics of military justice systems seem to have is the presumption that any difference between a country's military justice system and its civilian justice system indicates that that military justice system is somehow deficient as a matter of constitutional or international law. That any difference between how sailors, soldiers, aviators are treated indicates that they have fewer rights. And again, based on social, legal, constitutional histories, that may be true in some cases, but I don't think that that is a valid universal presumption that we should be operating under. Military members have the same rights as other citizens. But just because the civilian justice system does something in a particular way doesn't mean that that something is required by the Constitution or by international law. Nor does it mean that it would necessarily be a good policy idea if it's imported into the military justice system. Military justice system, military justice systems, and civilian justice systems exist for different purposes, and those purposes have to be recognized. Again, it seems to me that current international military justice systems tend to revolve around three axes. One is the one that General Dahl put up in his presentation in terms of the form and the composition of tribunals. And some of you may or may not know that we refer to that as the Dahl spectrum in short form. But there are two others, and General Dahl's presentation touched on both of those, I think, in a very complete way. The subject matter jurisdiction of tribunals, that is to say, is a military tribunal going to try purely military offenses? Will it try criminal offenses of general application? Will it try serious human rights violations and war crimes? Those are the subject matter of Articles 8 and 9, or principles, draft principles 8 and 9 of the Decaux principles. The other one is personal jurisdiction of the tribunal. That is to say, will the jurisdiction be limited only to military personnel? Will it be exclusive jurisdiction over military personnel to the exclusion of the civilian justice system? Under what circumstances, if at all, will there be jurisdiction over civilians? And I'd like to just make the point, and that's Decaux draft principle number 5. And the only caution I would raise, and my inter-American forum friends will recognize that this is a constant talking point of mine with respect to the Decaux draft principles, is to indicate that they represent a particular point of view, and in my mind, and this is a discussion that we always have about so-called soft law in the international sphere, that they are advocacy. The flashpoints, the challenges that I've just raised, that General Dahl raised, that Mr. Briggs raised, are all items where the Decaux draft principles take a particular point of view, and one that's not necessarily consistent with the practice. In fact, it's not consistent with the practice of all states, including many of the states in this room. It's notable to me in that respect that neither the Commission on Human Rights nor its successor, the Human Rights Council, have actually taken up the Decaux principles, notwithstanding the fact that Professor Nall, the Special Rapporteur on the Independence of Judges and Lawyers, suggested that in her 2013 report. And my point is, states make international law. Special rapporteurs play a role in attempting to define, and in this case I would say successfully defining, some of the points of discussion. But it's states that make international law. And I'll come back to my constant point that for those of us that work in this area, particularly in matters related to the Human Rights Council, and this is limited to military justice, this goes to other special procedures. I point to the working group on arbitrary detention, for instance, which had some very problematic draft principles referred to the Human Rights Council in the last year. States need to keep an eye on what's going on in Geneva. We may wear uniforms, we may deal in military matters, but what the Human Rights Council does and what its special procedures do matter. They count. They set out the ground for debate. And the states want to play a role in the formation of international law in these areas. States need to pay attention and to be engaged in those areas. The other thing that I think I might add to the discussion is to point out that the law of armed conflict and international humanitarian law plays a role here in the importance of military justice and how states comply with international law. In both international and non-international armed conflicts, IHL requires that states create accountability mechanisms. Internal disciplinary systems is the term used in Additional Protocol 1, as a means of ensuring respect for the rules of international humanitarian law and to prevent and repress violations of that law. Now, I will say that international humanitarian law is silent as to the form of those tribunals. It prohibits neither military nor civilian tribunals. Although there are some cases where it clearly anticipates the existence of military tribunals. On the human rights side, I've given you my perspective on the code, but there's absolutely no doubt that the International Covenant on Civil and Political Rights does apply to military justice systems. Again, what I would say about the ICCPR, I raise that in this context because that's the international instrument to which Canada is a party. Canada is not a party to the American Convention on Human Rights or the European Convention on Human Rights or any of the other regional instruments. The standard, and interestingly, it's reflected in Principle 13 that Mr. Briggs had up on the screen, is that the tribunal needs to be fair, the hearing needs to be fair and public. The tribunal competent, independent, impartial, and established by law. And in my submission, there are lots of ways that that can be done. It doesn't require a particular form or a particular set of jurisdictions. I want to say one thing about the term ad hoc tribunal. Mr. Briggs hunted that ball to me during this presentation. I've tended in the past to use that term in an offhand way that I think has sometimes been misunderstood. Those countries that retain so-called ad hoc courts martial, the US, Canada, Australia, that doesn't mean that the judges are just picked off the shelf for the particular proceeding. Australia and the United States both have mechanisms that within their own constitutional and legal structures provide for the independence of the military judges who are appointed to preside at the courts martial. In Canada, military judges are appointed in exactly the same way as superior court judges are appointed by the executive with secure tenure until they reach a fixed retirement age, which is the same retirement age as all members of the Canadian forces. Their financial compensation is provided for through an independent mechanism, and they possess all of the administrative independence that civilian judges do. So they have that independence as military judges, and then they are, as required, appointed to preside over courts martial, which exist for the purpose of hearing one particular matter. So in the context of whether it's desirable to have a standing court or not, I'm not sure that in the Canadian context there's a lot to be gained other than possibly the precedential value of previous decisions made by that tribunal. I want to talk just briefly and expand in the Canadian context upon a couple of the things that General Dahl raised when he discussed the challenges and the tensions. And this picks up again on the point that General Wilson made yesterday. Areas where there are sound, it seems to me, policy-based reasons that countries should consider retaining or establishing military tribunals with broad subject matter and personal jurisdiction. Think about counterinsurgency or peace support operations where the legitimacy, credibility of the deployed force, and the confidence of the local population are keys to success. In that sort of case, it seems to me that a standing and deployable, and Article 14 compliant, by the way, military justice capability allows the local population to see justice being done. And in this context, I'd say two things. Think about the allegations that have been made and have been subject to independent investigation and report by a Canadian retired Supreme Court judge regarding misconduct or alleged misconduct by peacekeepers in Central Africa. I understand from what I have read that the head of the part of the peacekeeping operations of the United Nations has, in fact, reflected aloud on the possibility of the United Nations itself establishing deployable justice mechanisms to apply to members of UN forces. I think that's probably not likely to succeed, but it does suggest very strongly to me that the United Nations as an organization sees a gap in the ability of some of the troop contributing nations to deploy justice in a way that will buttress the credibility not just of a sending state, but of the United Nations. Think also of the increased deployment of civilians. And so the examples that the General Dahl spoke of are entirely valid. We use civilians in ways that can engage our state's responsibilities. And there needs to be a mechanism to discipline them to ensure that when state responsibility is engaged, that we can ensure compliance with international law and repress violations of those. But I'm going to give an embarrassing example from a Canadian perspective that comes back to the UN's concern with sexual exploitation and abuse in peacekeeping forces. So on International Women's Day, the United States ambassador to the United Nations made a speech in which she made particular reference to Canadian peacekeepers in Haiti who were alleged to have exploited sexually Haitian girls and women. A couple of examples involve impregnating 15-year-old girls by Canadian peacekeepers. This was news to all of us in the Canadian forces, and as it turned out, the allegations were in respect of Canadian civilian police officers who were deployed to Haiti as members as a Canadian contribution, but not as persons accompanying the force, which would have made them subject to Canadian military jurisdiction. So when these allegations were made and became known in the peacekeeping mission, the choice in terms of how to address those, to investigate, try, and prosecute, was between the local Haitian justice system, from which members of the UN operation were immunized, or domestic Canadian criminal law. And like many common law countries, the Criminal Code of Canada does not apply outside of Canada, except with express exceptions, which were not engaged in this case. So individuals were returned to Canada, and they were disciplined under the local Quebec Police Services law. The result being what Ambassador Power found to be, and she's right, a completely unacceptable situation. The two involved were suspended without pay for 5 days and 9 days respectively. Had they been members of the Canadian Forces, had they been civilians accompanying the Canadian contingent in Kurdistan, it could have been dealt with through the extraterritorial application of both the Code of Service Discipline and the incorporated criminal. You've heard me speak on this matter before. In August, I had the opportunity, hosted by Admiral Araya, to speak at the Inter-American Forum in Del Mar. And my topic was the jurisdiction over ordinary criminal offenses of the Canadian justice system. And at that point, there was a case pending before the Supreme Court of Canada that addressed that issue. And as a result, I was a little cagey in how I phrased my opinions on the prospects of that case. I'm happy to report that as a matter of Canadian constitutional law, and I will say that Article 14 is almost verbatim repeated in various aspects of the Canadian Charter of Rights and Freedoms, our Constitution, that the Supreme Court of Canada has upheld military jurisdiction over ordinary crimes. In the case before it, that was cases of sexual assault and involving the use and trafficking of, possession and trafficking of drugs. And the Supreme Court of Canada held that the commission of those offenses by a person who's subject to the Code of Service Discipline is rationally connected to the maintenance of discipline, efficiency, and morale. In essence, saying that any indiscipline, wherever it takes place on the part of a member of the United Forces, is something that can affect military effectiveness and public confidence. I think I will close there. I'm happy to answer any questions either on the podium or afterwards, but I'd like to just close by coming back to, I think, the theme that we've pulled out of our discussions of military justice. Every military justice system is unique. It's been formed as a result of a unique set of factors. And in order to understand what best we can take from each other's systems and what best we might offer to each other's systems, we need to understand all of those unique aspects of each other's countries and legal systems. And this is what I think is very valuable about the society's work. It's very valuable about the work of the Inter-American Forum. I'm happy to be a part of it, and I look forward to working with you all in the years to come. Thank you.
Thank you very much. To the best of my knowledge, we don't have questions or consent so far. Is that correct? Yes. Okay. Then, since time is pressing and the lunch is waiting, I would like for our part of what is the main subject, which is the analysis. I would like to stress once again that military justice is there. It is in existence in the overwhelming majority of states across the globe. And since it is the case, and since the call on the ground seems to be that states recognize that definitely there will be a political overlay, the so-called democratic control of the military, then the question arises on what would be the substance of this with reference to military jurisdiction. And as you all know, this question has a very long and very loaded history, particularly in certain areas of the planet, such as here in Latin America, as it is also the case in Asia. And of course, the answer is not one and only, as very well rightly Rob Holman just pointed out. Because some nations, after years of debates and popular demands for change, tend to conclude that the military should always be some should after civilian life, meaning that civilians would also judge the military's actions as well, since life needs to be purged from politically motivated actors and unlawful attacks against civil society. And other countries show a different approach, as you may guess. What I would say simply on this is that each nation's answer is unique. It's based on factors such as history, experience, location of the country, tradition, internal situation, and security interests. Now, whatever happens, the administration of justice through military tribunals directly into the democratic control of the military raises serious concerns in terms of justice, impunity for past human rights abuses, independence, impartiality of military tribunals, and respect for the fair trial rights of the accused. Those concerns should be properly addressed in states where military jurisdiction is still in existence. Obviously, in the light of military courts constitute an integral part of the judiciary and function with competence, independence, impartiality, guaranteeing the existence and enjoyment of human rights, in particular the right to a fair trial and the right to an effective remedy. Reaching now the very end of this session, and before adjourning, it is the time, I believe, to express my appreciation, my deepest appreciation of the three speakers for the whole of the information they provided to us from the various corners of the planet. And it is the time to express this appreciation by delivering them this certificate, as this indicates during the whole of the works of this seminar, this conference here. More precious, I would say, paper, which is the get, because we as a reminder of what happened here in Lima over these 2 days. I think it's time to begin.
Vamos a reconocer a nuestro moderador en esta tarde. Por favor, invitamos al general Juan Pablo Ramos, presidente del Pueblo Militar, a entregar el certificado de agradecimiento a nuestro moderador. Por favor, intermedio en sus asientos, porque vamos a hacer un aviso importante. Mientras se instala la mesa para un reconocimiento y conmemoración, Les recordamos a todos los participantes extranjeros que deben verificar la salida de sus vuelos. Asimismo, a las personas que van a participar de la jornada cultural en el estado de que todavía no se han inscrito, lo pueden hacer hasta el día de hoy, son 12 de la tarde. Los certificados de participación, tanto para los extranjeros como los nacionales, serán entregados al concluir la jornada académica. Me informan que si en los certificados hubiera algún error con los nombres obligados, con la Secretaría Técnica se podrá hacer la corrección inmediatamente.
Damas y caballeros, a continuación se llevará a cabo una ceremonia especial el día de hoy. Por temas estrictamente del servicio, el general Paul Wilson tendrá que partir a los Estados Unidos en breves horas, por lo cual no queremos dejar la oportunidad. Invitamos al señor Paul Wilson y al señor presidente del Fuero Militar Policial ocupar su lugar en la mesa de honor para hacer la ceremonia de condecoración y entrega de condecoración para la teniente general Flora Dalpino, y además hacer presente al señor general Paul Wilson.
Señor secretario, ¿de cuenta de la agenda? Señor presidente, se ha programado para la fecha la condecoración anunciada, por lo que procedo a dar lectura a la resolución administrativa número 007-2016 FMP CESG de fecha 15 de marzo de 2016, considerando que por ley 29.182, Ley de Organización y Funciones del Fuero Militar Policial, se estableció la naturaleza, estructura, organización, competencia, jurisdicción, funciones y atribuciones del Fuero Militar Policial, como un organismo autónomo e independiente en armonía con las normas y principios establecidas en la Constitución Política del Perú, que mediante directiva número 012-2013 de fecha 27 de marzo de 2013, modificada en sesión del Consejo Directivo de fecha 18 de febrero del presente año, se establecieron A2 literal 3 de la citada directiva, se estableció como condecoración especial la orden del Fuero Militar Policial, estableciéndose sus diversos grados y requisitos. Que se estableció que la condecoración Orden del Fuero Militar Policial en el grado de Gran Oficial Distintivo Blanco podrá ser otorgada a dignatarios, autoridades, funcionarios y personalidades civiles, militares, policiales, diplomáticas, académicas y eclesiásticas del ámbito nacional e internacional, a propuesta del presidente del Fuero Militar en su calidad de canciller de la Orden y con la aprobación del Consejo Ejecutivo del Fuero Militar Policial. Que en sesión del Consejo Ejecutivo del Fuero Militar Policial, a propuesta de su presidente, se acordó que en el marco del tercer Congreso Internacional sobre Derecho Militar se otorgue la condecoración Orden del Fuero Militar Policial en el grado de Gran Oficial en Distintivo Blanco a la señora Teniente General Flora Darpino, Auditora General del Ejército de los Estados Unidos de Norteamérica, quien reúne los méritos suficientes para ostentar la citada medalla, por lo que de conformidad con los fundamentos expuestos se resuelve. Artículo único. Otorgar la condecoración Orden del Fuero Militar Policial en el grado de Gran Oficial Distintivo Blanco a la siguiente persona: señora Teniente General Flora Darpino, Auditora General del Ejército de los Estados Unidos de Norteamérica, en reconocimiento a sus invalorables y trascendente trayectoria profesional y personal en el ámbito de la justicia militar internacional, así como por su importante contribución con el fortalecimiento de los lazos institucionales y de amistad con la justicia militar de nuestro país. Regístrese, comuníquese y archívese. Firmado Juan Pablo Ramos Espinosa, General de Brigada, Presidente del Fuero Militar Policial y Canciller de la Orden del Fuero Militar Policial.
A continuación, invitamos a hacer uso de la palabra al señor presidente del Fuero Militar Policial para la entrega de la condecoración de la Teniente General Flora Darpino, Auditora General del Ejército de los Estados Unidos, quien en su representación lo recibirá el día de hoy es el general Paul Wilson.
Señor General de Brigada Paul Wilson, del Ejército de los Estados Unidos. Hace algunas semanas recibí con mucha pena la comunicación de la señora General de Brigada Flora Darpino, Auditora General del Ejército de los Estados Unidos de América, quien nos hacía saber que debido a las obligaciones en su despacho se veía imposibilitada de asistir a este congreso y al acto de condecoración donde nos hemos propuesto galardonar. Sin embargo, encomendó dicha misión a usted, señor general Paul Wilson, quien es parte de su comando y tiene la mayor de sus confianzas, de manera que, estimado general Wilson, usted nos ayudará a hacerles llegar a la señora general Darpino este reconocimiento, que es nuestra máxima expresión de gratitud y estima a quienes fortalecen y engrandecen la justicia militar peruana. Hay algo que todos los presentes deben recordar, y es que la señora general de brigada Flora Darpino es la primera oficial mujer en asumir el máximo cargo de la justicia militar en el Ejército de los Estados Unidos de América. De por sí, es un gran mérito y un éxito muy notable, no solo por ser una dama, sino sobre todo por ser una magnífica profesional. Ella tiene una trayectoria increíble desde sus inicios como oficial, luego de haberse graduado con los más altos honores en las facultades de Derecho en Pensilvania y New Jersey, Ha ejercido en el cuerpo jurídico del Ejército de los Estados Unidos desde 1987, habiendo realizado una brillante carrera en distintos cargos como asesora, abogada defensora, responsable del servicio legal y de derecho administrativo. Su labor incluye misiones en distintas divisiones del ejército de su país, incluyendo Irak. Ella ha sido comandante de la Agencia de Servicios Legales del Ejército de Estados Unidos y comandante de la Escuela del Centro Legal y Escuela de la Justicia Militar estadounidense. Nuestra amistad con la justicia militar de los Estados Unidos tiene una gran fortaleza, gracias al impulso y compromiso de la señora general Flora Dalpino, quien ha visitado nuestro país en 2 ocasiones. La primera vez fue como general recién ascendida, el año 2012, junto a un grupo de oficiales del cuerpo jurídico del Ejército de los Estados Unidos en misión de estudio, y la segunda vez estuvo con nosotros el 16 al 19 de julio del año 2013, participando en el primer encuentro multilateral junto a representantes del Comando de las Instituciones de Justicia Militar del Perú, Chile, Colombia y Estados Unidos de América. Desde entonces, su identificación con el grupo de trabajo sobre justicia militar y el Foro Interamericano ha sido determinante, y estoy seguro que en estos momentos estará muy interesada por conocer lo tratado en este congreso. A la señora Teniente General Flora Dalpino, auditora general del Ejército de los Estados Unidos, quiero, en nombre del Fuero Militar Policial del Perú, expresarle toda nuestra gratitud y reconocimiento a su gran labor por el fortalecimiento de la justicia militar en mi condición de canciller de la Orden, y imponer la medalla de la Orden Fuero Militar Policial, solicitando a usted, señor general Paul Wilson, hacerle llegar este reconocimiento, que es el cariño y la consideración del Fuero Militar del Perú a su digna persona. Gracias. A usted, señor general de brigada Paul Wilson, comandante de la Agencia de Servicios Legales del Ejército de los Estados Unidos, como magíster en leyes por la Escuela Jurídico-Militar de su institución, y tiene una maestría en ciencias por la Escuela Nacional de Guerra y numerosos cursos tanto en su especialidad como también en armas, incluyendo el de paracaidista. Se ha desempeñado igualmente en una diversidad en la primera división militar durante las operaciones Escudo del Desierto y Tormenta del Desierto, entre otros importantes cargos. El día de hoy jefatura la Agencia de Servicios Jurídicos del Ejército de los Estados Unidos. Algo muy importante de destacar es su voluntad por participar de manera constante en los encuentros de la justicia militar que se ha realizado en el Perú y en muchas partes de América. Hemos contado en varias oportunidades con su valiosa participación y el aporte invalorable de su experiencia en el campo de batalla, mediante exposiciones como la realizada el día de ayer. Y qué honor recibir y escuchar a los peruanos, escuchar de su parte de que los miembros de las Fuerzas Armadas que participaron en Haití y otros lugares han demostrado una brillante conducta, intachable. Por ello, señor general Wilson, muchas gracias por su contribución, por su conocimiento, experiencia y apoyo decidido para fortalecer los lazos de amistad y trabajo en los temas relacionados con las Fuerzas Armadas y la justicia militar, en bien de la paz mundial. Muchas gracias.
Invitamos al señor presidente del Foro Militar Policial y al general Paul Wilson delante de la mesa, por favor, la mesa de honor, para recibir en primer término la condecoración a la general Flora Lapino y luego también el presente recordatorio del Foro Militar Policial al general Wilson con motivo de su visita al Perú.
General Paul Wilson, como he manifestado, haga la entrega esta condecoración a nuestra general Lapino en reconocimiento a su apoyo a la justicia militar del Perú y América. Señor general, la justicia militar del Perú siempre lo tuvo presente en todas las conferencias que se han realizado en los últimos años. Y en ella usted ha expresado su sentimiento por la justicia militar y además ha volcado hacia nosotros su experiencia en un campo de batalla, siempre en busca de la paz y la seguridad. Por eso es que también hacemos entrega para usted, señor general, esta presea de la justicia militar.
Invitamos a tomar asiento, por favor. A continuación, invitamos a hacer uso de la palabra al señor Brigadier General Paul Wilson.
Muchas gracias. I will be brief because I know that we're delaying lunch and everybody is likely to be hungry. But let me first say on behalf of Lieutenant General Barbino, who was unable to be here, sir, but whose heart is here. She very much did everything she could to rearrange her schedule and attempt to actually attend this meeting. She has made connections with members of the Peruvian military, Chilean military, and many others that are very important to her. And the issues that you come together to work in these types of forums are very important to her. For her inability to be able to attend this, I have spent time with her over the course of the last few years. General Barbino asked me to convey to you her great appreciation in your recognition of her with this incredibly distinguished award. She recognizes that this is a very important honor and that it is not everyone who receives such high recognition. And so she is greatly honored by your presentation of this award. And I will ensure that, in fact, I will see her on Sunday. I will ensure that she receives the award at that point, and she will appreciate the award. With respect to the award that you gave me, thank you very much. It is an honor, as always, to participate amongst such a great group of colleagues. General Barbino did ask me to do one thing, though. In recognition of the award that you provided her, she wanted me to provide you with a
I say we eat lunch.
Le damos un fuerte aplauso, por favor, a Partido tendrán que partir esta tarde rumbo a los Estados Unidos nuevamente. Muy bien.